Well, good afternoon, everyone. Thanks for joining us for this webinar this afternoon. For those of you who don't know me, my name's Adam Rice. I'm one of the senior lawyers in the Employment and Business Immigration team at Travers Smith. And we've got our resident immigration expert with us, Moji Yidaran. Well, it's hard to imagine that up until about 6 months ago, Brexit was all that anybody was talking about. That's clearly been eclipsed by recent events in the recent months. But the Brexit transition period is coming to an end at the end of this year. So all of us are going to have to get up to speed with a new immigration regime in the next few months. So we wanted to put Brexit back on the agenda and to think about what you need to do to prepare for next year. So in terms of what we're planning to cover this afternoon, we're going to take a look at the current immigration regime, just by way of quick reminder. And then we'll turn quickly to Brexit and look at the current position. So where are we currently in relation to Brexit? And then we wanted to look at the post-Brexit immigration regime. So how is the new regime shaping up for next year? Then finally, we'll take a look at right-to-work checks, what's changing there, and wrap up with a few ideas on how you can start to prepare for next year. Now, we're going to leave some time for questions, so do submit your questions throughout via the Q&A function, which should be at the bottom of your screen. We'll do our best to pick them up as we go or at the end. So jumping straight in then with the current position in terms of the immigration rules. So what does the current regime look like? Well, there's currently a clear distinction between EU nationals and non-EU nationals. And the regime for non-EU nationals, so people from Australia, America, Japan, is broken down into 5 tiers. It's a 5-tier points-based system. So tier 1 covers high-value applicants, so high net worth investors, innovators, those looking to start up a company in the UK for the first time, and also leaders or world leaders in their fields. You're probably not going to come across tier 1 all that often. In reality, as an employer, the tier you're most interested in is tier 2, and that's the employer-sponsored skilled worker visa route. We'll talk a lot more about tier 2 a bit later on, because the new immigration regime post-Brexit is going to be largely based on the tier 2 regime. So we'll definitely come back to that. Tier 3 is largely irrelevant for all intents and purposes because it covers lower skilled roles, but tier 3 has never been brought into operation and it's currently suspended. There was some speculation that it might come into play post-Brexit, but there's nothing from the government thus far that suggests they are going to bring tier 3 into life. So we can ignore tier 3 for the moment. Tier 4 covers student visas. Again, most employers won't come across student visas very often. These are students studying at an educational institution and the institution sponsors the visa. Where you might come across a student visa is if you're looking to recruit someone who's on a student visa, because students are allowed to work subject to restrictions depending on the type of visa that they have. So most students will be allowed to work during term time, but only part-time during term time and then full-time during holidays. Finally, the other category that is relevant for lots of our clients is tier 5, and that's because this is a category which covers a range of temporary routes, including internship visas under the government authorised exchange programme, and also working holiday makers under the tier 5 youth mobility scheme. So that's a very, very quick whistle-stop tour of the current regime in relation to non-EU nationals. Where are we then in relation to EU nationals? Well, as I'm sure you all know, we've left the EU. We left the EU at the end of this year. And the whole point of the transition period is basically to maintain the status quo. And what that means is rights to freedom of movement continue to apply during transition, right up until the end of this year. For EU nationals, that means that if you're a national of the European Economic Area or Switzerland, you can come and work and live in the UK without any visa and any restriction at all. So you've got the freedom to come and go. But of course, all of that is changing at the end of this year when freedom of movement will come to an end. And so from the 1st of January 2021, there's going to be a completely new immigration regime, which will apply to EU and non-EU nationals. And we'll talk a lot more about that a bit later on. Before we come on to the new regime, we wanted to have a think about your existing employees and who you should be worrying about there. And Moji's going to take us through that now.
Thanks, Adam. So, as Adam said, who do you really need to think about when we're looking at planning as we head into the final months of the Brexit transition period? So, you have, with your existing EU employees, you need to really think about 4 key groups. Some are slightly more obvious than others, and I'll go through some of these key groups to think about. So firstly, you've got your existing EU employees who are already working for you and are based in the UK. So for this group, they are clearly the most obvious affected by Brexit. So we'll come on to think about what steps they need to take. Secondly, you want to consider, if you have overseas offices, anyone you have is a UK passport holders working for you in one of the remaining 27 EU member states, because again, they will be impacted by the changes coming up. Then you've got the slightly less obvious groups, but who are still impacted, who we'll come on to talk about the steps for them. But you have your EU nationals who are who are employed by you, but who actually don't live in the UK, but will regularly come. So perhaps somebody who lives in France, who comes over on, say, the Eurostar and works on a weekly basis, but their family remains abroad. Or you might have people who work sort of in other similar cross-border arrangements. Now they will be impacted by Brexit, where they are an EU national. And then finally, you want to think about what happens for your UK passport holders. Now, of course, at the moment, business travel within the EU is entirely hassle-free, and you don't really need to worry about sort of what happens when people get to the border. But as Adam has said, that is all set to change because EU free movement rules will be ending at the end of this year. Now, lots of employers, and you may already have done an audit of all your existing employees, but if you haven't done that yet, you want to have that on your to-do list, really, because you really need to have a good view of how many people you have in each category, so that you can plot and work through what the best steps to take so that you can protect their position as far as possible. Now, if we turn to the first group that I've mentioned, so your EU nationals that are working in the UK. So they are in the best position, really, because there's been an agreement with the EU, and their status, their sort of right to remain and living and working in the EU, in the UK, will be protected under the withdrawal agreement. But what they need to do is that they need to apply for status under what the UK government has introduced, the EU settlement scheme. Now, they have plenty of time to apply because the deadline is not until the 30th of June next year. Generally, the process should be straightforward for most employees. There's an app that they need to use to verify their ID, and then they complete an online application form, and typically residence is verified by their NI number, so HMRC records of their contributions. So for most people, it'll be fairly straightforward, but you may get some employees who need to come to you for some evidence. So they may need to provide a letter confirming their employment, or they may need copies of their P60s, for example, or pay slips. So just be aware that there may be some individuals who need to provide, ask for assistance with documents. Now, the thing to remember for now is that it's not yet mandatory to apply for status. So as I said, the deadline is not till the end of June next year. So while you want to encourage your employees, EU employees, to be applying, you shouldn't be insisting on them having the documentation from the EU settlement scheme as evidence of right to work when you're checking that either at the onboarding stage or on ongoing right to work basis. We will come to talk more about what requirements will apply for right to work purposes, but that's quite key. You want to make sure you're following the rules and not risking any potential discriminatory claims. Now, if you move on to your UK employees that are based out in the EU, where this applies to you, well, similarly, they will also need to apply for status. They're protected under the withdrawal agreement, but they need to get that confirmed by way of a document. Now, the process they need to follow and the document they'll be issued with will depend on which country they live. So they'll need to make sure they follow the steps set out by the country, by the EU 27 member states in which they're living. Now, they do need to make sure they apply by the 30th of June, so similar, exactly the same deadline as EU nationals in the UK. And again, you want to sort of encourage people to make sure they're making those applications in good time before the deadline.
Moji, we just had an interesting question here. Is there any prospect of the deadline for applying for settled status or pre-settled status being brought forward in the event of a no-deal Brexit?
Yes, that's a really good one, because obviously we've had all the sort of the discussions recently around, you know, what happens with the withdrawal agreement and whether we will get a trade deal. For there to be a change, I think both parties, so both the UK and the EU, would have to agree to a different date. At the moment, there's no indication that either side wants to extend that deadline. There was an option for the UK to ask for an extended transition period, and that didn't happen. And the UK has been quite clear they don't want to do that. And on the UK side, all the sort of the legislation that underpins the settlement scheme has been set with that deadline in. So I'll be surprised if there is a change to the date.
It's quite unlikely. I would have thought that the date would be brought forward. I don't think any of the member states want to give themselves less time to deal with EU nationals or UK nationals in their jurisdiction. So I think that deadline of the 30th of June next year is pretty settled.
Yeah. And one other question that's come up, which I think is worth just flagging and pointing out here, is the position for Irish nationals. So Irish nationals will not be caught by this new requirement to apply for EU settlement scheme because they have special status in the UK. And both the Irish government and the UK government have committed to ensuring that remains, irrespective of the changes that will come up at the end of the transition period.
And before we move on from this, just one other question that's come in. Is there a list anywhere of all of the different application processes for the different EU member states? And sadly, whilst that would be very useful, there isn't. So if you've got people working in different EU countries, unfortunately, you have to go to each jurisdiction and work out what the application process is in that jurisdiction, because they all vary. In some cases slightly, in other cases quite significantly, the application process varies. Okay, just coming on to the next category of employees that Moji mentioned earlier. So far we've been talking about people who are stationed in just one place. So people either working in an EU country or working in the UK. But some of our clients have employees who work across borders. say someone who lives in France who regularly works in the UK. And these are called frontier workers. So that's somebody who lives in one EU country but regularly works in another. And they are going to be protected at the end of the transition period. Obviously, at the moment, it's not a problem at all because freedom of movement applies. So it's very easy to come and go. But once the transition period comes to an end, then it's a different story. If you've got employees in this category, they are going to need to make an application to preserve their status as a frontier worker. Now, unfortunately, the application process isn't open yet, but it will be similar to the EU settlement scheme, and employees will also have until the 30th of June next year to apply. So it's just worth identifying now whether you do have anyone in this category, so anyone who works across borders, and perhaps just getting them lined up to the idea that they're going to have to make an application towards the end of this year or early next year once the application process opens.
So moving on then to business travellers, as I mentioned, there will be an impact for UK passport holders who actually travel to the EU 27 member states once the transition period ends. So the reason for this is that actually at the moment, obviously because of the transition agreement, we're still considered as if we were EU nationals, effectively enjoying free movement rights. Once the transition period ends, then we would be considered as a third country national or any other non-EU national who is entering the EU. So what that means is that there will be a different sort of entry regime that a UK passport holder will need to meet. Now, it doesn't mean that a UK national will suddenly automatically need a visa to go for a business meeting in Belgium, say. And we have had confirmation from the EU that the UK would be added to the non-visa list in terms of business visits and sort of Schengen area entry. However, it does still mean that you will need, a UK passport holder will need to show that they meet the requirements for entry for a business visit. So typically it will be the activities that they are undertaking in the EU will have to be within a limited range that is permitted for business visitors. So typically a meeting would be fine, but you couldn't send a UK passport holder to provide, say, sort of holiday cover for a colleague in the Brussels office because they wouldn't have a right to work, as is currently the case. People also need to be, I guess, made aware that there is that change because there will be a different regime when they arrive at the border, where they may well be asked to confirm what they're coming to do, how long they're planning to stay, and essentially confirm they have funds to cover their duration of stay. So now if you have frequent travellers, you may want to think about whether they need to have a letter that they can refer to. Now they may not need it, but the letter would be something fairly simple that just confirms that they're based in the UK, their role, and a summary of what they plan to do while they're visiting the EU, and particularly confirmation that they're not going to be doing any work while they're there. So, as I said, they may not need it, but because it's a fairly big change, having something that individuals can refer back to will be helpful, particularly in the early months where the change might be more difficult to sort of come to terms with. Now, where you do need individuals who are to go and work in your EU office, you're going to have to think about getting them visas, and that will, in line with the local requirements for the country that they're going to, and that will mean that you have an additional administrative and timing considerations as part of any sort of secondments that you may at the moment do without sort of having to plan so far ahead. Post end of Brexit transition, there will need to be a bit more timing considerations around getting visas. It can take an average of 3 months in some places. So that needs to be factored in.
Absolutely. And just before we move on, Moji, there have been a couple of questions here around the same point around UK nationals working in Ireland. Will they need to apply for any sort of residence documentation, or are they covered by this exemption that you mentioned earlier?
Yeah, so it's the exemption, the special status, I guess, of Irish nationals and UK nationals in Ireland is protected in both places. So the Irish government have also confirmed that they will not impose new restrictions on UK passport holders in Ireland. So that does make things easier for them. So an Irish national in the UK doesn't need to apply for the settlement scheme, and a UK national in Ireland also would not need to apply generally for the scheme in place there.
Great, that's good news. Okay, so now we're going to move on to the new immigration regime. So far we've been looking at your existing employees and what you need to be thinking about for them. But what about new hires from next year? So how is the new regime going to affect your recruitment? So we're looking at recruitment from 2021 onwards. As I mentioned earlier, there's going to be a new immigration regime from the 1st of January. And it's quite a big change for new hires from the EU. And that's because at the moment, EU nationals don't need any type of visa to come and work for you. They just show their passport or their national identity card, and that's all you need. But from January 2021 onwards, anyone that you hire from the EU coming to the UK for the first time is going to need a work visa. And under the new system, EU nationals will be treated in exactly the same way as non-EU nationals. So they'll have to satisfy the same visa requirements as non-EU nationals, and there'll no longer be any preferential visa categories. What that really boils down to for employers is quite a significant increase in cost and also compliance. For most new hires who are coming to the UK for the first time from the EU, you're going to need a sponsored visa, similar to the Tier 2 sponsored visa. And of course, that means you're going to need to have a sponsor license. And we'll talk a bit more about that a bit later on. But I just want to recap quickly what the current Tier 2 visa route looks like. And then we're going to contrast this with what the new sponsored visa route will look like from next year. So this is the current regime for Tier 2 visas, which applies currently to non-EU nationals. So as a starting point, the role that you're recruiting for has to meet a minimum skills threshold. And as I said, the employer has to have a sponsor license in order to be able to sponsor somebody under Tier 2. And so the key thing is to have the license in place. Then, as I mentioned, there's a minimum skill threshold for the visa, and that's currently set at quite high. It's NQF level 6, which is broadly equivalent to a senior managerial role or a bachelor's degree level role. The individual also needs to speak English to an acceptable level, and they do that, or they demonstrate that, by having a degree that was taught in English or by undertaking an English language test. But one of the key challenges with the current Tier 2 route, and many of you will be familiar with this, is the resident labour market test. And that's the requirement for you as the employer to advertise the role for 28 days and be satisfied that you can't find somebody suitably qualified from the local workforce to do the job. So you can't find someone who's a UK national or an EU national already with the right to work in the UK who can do the job. And for lots of roles, that's quite difficult because you're not looking at necessarily the best candidate for the role. You're looking at anybody who has got the right qualifications, who basically can do the job, who meets the minimum requirements. Now, there is an exception for high earners. So if your role is paying 159,600 or more, then you don't have to worry about the resident labour market test. But for anything under that, you do. Now, there's also a minimum salary threshold under Tier 2 at the moment. So at the moment, you have to pay at least £30,000 for the role. And that's subject to any higher going rate for the job set out in one of the Home Office codes of practice. The Home Office has got a set of codes of practice called the SOC codes, or the Standard Occupational Codes, which cover most jobs, and they set out the minimum going rate for the role. So if you were recruiting, say, a marketing director, for example, the minimum salary for that role is actually $49,900. So you'd have to pay at or above that rather than the 30,000. And finally, there's currently a limit on Tier 2 visas, which can be a problem. So at the moment, Tier 2 general visas are limited to 20,700 a year, and that's broken down into a monthly quota. And so if you're wanting to recruit somebody, you've got to apply for a sponsorship certificate out of that monthly quota. And if the monthly quota has been hit, then you're likely to miss out. And we've seen that happen quite a bit in the last couple of years. So that's what the current Tier 2 sponsored visa looks like. And Modi's going to take us through what the new skilled worker visa is going to look like next year.
Right, so what can we expect from this new skilled worker visa route? Well, the first thing to say is that it's actually closely modelled on the existing Tier 2 route that Adam has just outlined. But there are some key changes, because what the government is trying to do in the UK is expand the route to also include EU nationals, as well as the existing non-EU nationals already covered. So some of the changes will, I think, be welcomed by employers who currently use the Tier 2 route. So it will still be a points-based route, so individuals will still need to score points to get through, and it will be a 70-point minimum sort of threshold they need to meet. They will be able to score the points by looking at a set of characteristics. So that will include things like, the fact that they have a job offer from a licensed sponsor, and there'll still be a minimum skill level. The language requirements and also a salary threshold will also be part of the new scheme. Now, the good news will be that some of the current requirements that Adam outlined, including the advertising requirements, which is the need for employers to go through an advertising process of 28 days, and the annual quota that as Adam mentioned, can be quite problematic. Both of those will be removed, and that's expected to make applications a lot quicker to process. It'll be possible to trade off some of the requirements to score points to make up the total of 70 points needed. So I think it's worth looking at how the point scoring will actually work in practice and sort of drill down a little bit into how that will work. So as I said, the individual needs a job offer, and that still will have to be from an employer with a sponsor license. So any employer who does want to sponsor EU nationals in the new regime will need to have a license in place, and the individual would score 20 points for having an offer from a licensed sponsor. They will also score 20 points if they meet the skill level. Now, the skill level at the moment is graduate level, but under the new regime, it's actually going to be a lower NQF level 3 threshold, which is equivalent to A level. So what that will mean is that there will be a wider pool of jobs that could potentially be sponsored under the new skilled worker route. Okay, so that gets us to the first 40 points that the individual needs. As I said, they do need to meet the English language requirement as well, and that will still be set to level B1, so that's intermediate speaker. And there are certain countries that have been designated as being English speaking for the purposes of this requirement. So somebody from Australia, the US or Canada, they would automatically be able to score the 10 points needed for English. If the individual is from elsewhere, including the EU, then you'd be looking at whether they have a degree that was taught in English. So if they've studied in the UK at some point, or in the US, or say Canada, they would be able to rely on that degree. Otherwise, they need to take an English test in order to pass, get the points needed for English. So then that gets us to the 50 points, that's the mandatory initial threshold, and they then need to make up the 20 points to get to the 70 needed by a combination of the salary for the job being at the going rate. So that concept will still remain under the new regime. The job will need to be assessed against the government set classification codes for jobs, and individuals would score points on the basis of their job being above the now lower NQF 3 level that will be going. And where individuals are being recruited for a job that is in a shortage occupation in the UK market, or they have a relevant PhD or STEM PhD that's relevant to their role, they may be able to get additional points or trade off the points that they need to get the basic 70 to get over the threshold. And Adam will look at the other category that's relevant to employers.
Yes, thanks, Moji. So as well as the skilled worker route, there's this new intra-company transfer route, which actually largely mirrors the current Tier 2 intra-company transfer route. And lots of you will be familiar with this. This is where you're an international organization and you've got offices abroad, or you've got group companies abroad, and you're wanting to bring employees who work for you in one of those offices or group companies abroad to work temporarily in the UK. Now, again, you need to have a sponsor license to do this, both under the current regime and under the new regime next year. And you need to make sure you're registered under the intra-company transfer route. And this is worth checking because lots of our clients have found out that they've been registered under, say, the Tier 2 general route, but not necessarily under the intra-company transfer route. And if that's the case, then you'll want to make an application ahead of next year to expand your license to cover both categories to make sure that you can use both next year. Now, it's also worth pointing out for this visa route, there's a much higher skill level than the skilled worker route. So for the intra-company transfer route, it stays at this NQF level 6 or above. So we've said that that's a senior managerial role or a role requiring at least a bachelor's degree. So if you're bringing people in from abroad who work for you abroad just temporarily, then that's going to be limited to more senior skilled employees. Now, on the flip side, the employee doesn't have to demonstrate any English language ability. So if you're bringing someone from Spain, or France or Germany or wherever it is from the EU, there's no English language requirement there for the intra-company transfer route. But there is also a much higher salary. So Moji said the skilled worker route will have a minimum salary of £25,600. For the intra-company transfer route, you'll need to pay a minimum salary of at least £41,500. And again, that's subject to any higher going rate for the particular role. And then the final point to flag here on the intra-company transfer route is that this is a temporary visa. So it's only to bring people into the UK temporarily, not for them to settle here. So there'll be a maximum of 5 years on the intra-company transfer, except for high earners who'll be able to stay for 9 years. But in either case, the individual won't be able to settle or go on to apply for British citizenship after being on an intra-company transfer. If the individual does want to settle or stay longer, then what they would be best to do would be to switch from a intra-company transfer to a skilled worker visa. And the very good news about the new regime is that will be possible. So at the moment, it's not possible to switch from a Tier 2 intra-company transfer to a Tier 2 general. but from next year, it will be possible to switch from an intra-company transfer to a skilled worker route. So that's quite helpful. We've got just a couple of quick case studies here to highlight how the points system works.
Yeah, so looking at the first one, which will focus on the skilled worker route. So we have somebody who is a Spanish national who has a job offer as a software engineer. Now, his salary for the new role would be £35,000 per annum, and the start date is expected to be the 1st of February 2021. So we're in the new regime, and he would need to qualify under the skilled worker visa route. Now, let's look at whether or not he would qualify. So firstly, we need to look at the first set of points. So the initial 20 points would be awarded if his job offer is from an employer who already has a license or applies and gets a license in order to get the individual Jamie sponsored. So the next thing to look at is the skill level requirement for the role under the job offer, whether that meets the threshold. Here, he has a job offer that is, so for those who aren't familiar with the tier 2 route, the way, the same position, the same way of assessing the skill level will continue to be used. So you need to match the job to one of the occupational codes that the government has set. Now, a software engineer matches SOC code, the occupation code 2136. And that is at level, graduate level. So he would meet comfortably the new lower threshold. Now, he would get 10 points if he has a degree that was taught in English or passes an English test. As a Spanish national, he can't rely on the designated countries exemption that allows him. So, he's not from Canada or the US. So the final 20 points, in this case, because he's been offered a job at 35,000, he's comfortably over the 25,600. But remember, we need to also look at the going rates that's relevant to the job type. In this case, we've worked out that it's covered by job type 2136. And the rate for that, you need to identify from the government's sort of criteria that they've set. The rate for that is 33,300. So again, his salary here would meet the requirements and it would comfortably get through. Now, sorry, go on.
Can I just ask you a question? Because the questions come in about the job classification codes and the going rate. Yeah. And the question is, where do you find these going rates for the various jobs under tier 2 and under the skilled worker route?
Under the current, should I answer that first part of the question first?
Thank you.
So under the current tier 2, all the codes are online under the UK immigration rules. So you can go onto the government website and do a search and find the relevant code. Now you have to compare the code to your detailed job description to work out whether it matches. Under the new regime, there will be updated immigration rules released that will actually set out the codes that will be covered under the skilled worker route. The government has released a policy paper that gives an indication of the jobs they think will be covered. So it is on that list, and some of you may have already seen that the policy guidance on that. So there's a full list of jobs in that document.
Yeah. Another question that's come up here, which is relevant, I've been talking a lot about having a sponsor license. And the question is, if you've got a sponsor license under the current regime, do you have to reapply for a license under the new regime? And the good news with that is you don't have to reapply if you currently have a license. So if you're currently licensed under tier 2, that will automatically convert over onto the skilled worker route. And if you're licensed under tier 2 intra-company transfer, that will automatically convert into an intra-company transfer route, which is why one of the key takeaway points from today's webinar is apply now for your license if you haven't already got one, and apply for those categories that you're not already licensed in, because that will set you up very nicely for next year.
And one other question that I've seen that just sort of, because it touches on the tier 2 and the skilled worker route, is in relation to the annual limits that we mentioned earlier. That limit that is applicable at the moment is for all employers that are looking to bring people into the UK. So it is a fixed 20,700 number of certificates, and which are then divided per month. So it can impact whether or not individuals can bring their employee, their new hire to the UK. So it's helpful that is going. I'm sure that will be welcomed.
Absolutely. So I'll just bring us on to our second case study. I appreciate there are some more questions, and we will come back to those at the end. The second case study is all about the intra-company transfer route. So here you've got Melanie, who has worked for Global Investments Limited for 4 years in the Paris office, and she's a French national. Her annual salary is equivalent to £50,000, and the business asks you if she can undertake a 6-month secondment in the London office in the UK. Well, given she's got more than 12 months service with the company abroad, and she's going to be paid above the minimum threshold of 41,500. Based on that, she will qualify for an intra-company transfer visa. So as long as Global Investments has a sponsor license and is licensed under the intra-company transfer route, then getting a visa for the secondment should be pretty straightforward. One of the other things I really wanted to touch on, because this is quite significant in terms of what's changing, is visa fees. Now, at the moment, as I said, EU nationals don't need a visa at all. So there aren't really any fees associated with getting a visa for them. But going forward, the government's confirmed that the same fee levels will apply to EU nationals as those that currently apply to non-EU nationals. And if you're looking at a sponsored visa for, say, 5 years, then your total visa cost is going to be just under £9,500. And let me break that down for you. So at the moment, a visa fee, the application fee for 5 years is just over £1,000. And on top of that, the employer has to pay the immigration skills charge, which is £1,000 per year of the visa. So that's £5,000 for a 5-year visa. Now there's a reduced charge for small employers, but it's generally £1,000. And then on top of that, there's the immigration health surcharge, which is to contribute to the costs of running the NHS. And that's increasing to £624 per year per applicant from October this year. So again, over £3,000 for a 5-year visa, which gives you your grand total of just under £9,500 for your EU national. Now, that doesn't take into account any dependents. So if you've got a spouse or children applying as well, there'll be costs associated with them. And it doesn't take into account any expedited processing application fee. So you might want to pay some additional fees to make sure you get your visa back quickly. But that will be on top of the £9,500. Now, of course, you can get a shorter visa, so you could get something for less than 5 years, and the cost would reduce proportionately. But those are the figures. I just wanted to give you an indication of how much additional costs you're going to have to face recruiting an EU national from the EU for the first time from next year onwards. Okay, moving on now to some other routes which don't require sponsorship. And Moji's going to take us through those quickly.
So where you have somebody, particularly if you're looking at a lower skilled role or something more temporary, there are some other options that are worth exploring. So the first one I'm going to look at is it's a new route that's been introduced next year under the new immigration regime. It's a graduate route. Now, this will launch in summer of next year and will allow international graduates who have completed a degree in the UK to actually stay on for up to 2 years in order to work in any job. So the skill level won't be relevant, and it could be for an employer that doesn't have a license. If PhD graduates want to use this route, they would be able to get a 3-year period. So that can be helpful for your entry-level roles. You might want to consider whether they have studied in the UK and could take advantage of this graduate route. Now, the other route that you may come across as well is the youth mobility scheme. So now that's an existing route, it's already in place, and it will continue under the new regime that's been confirmed. So it allows young people, so 18 to 30-year-olds from one of 8 specified countries to actually apply for a 2-year visa to come to the UK to work. Again, the work they undertake can be any job at any skill level, and the employer wouldn't need to have a license. The 2-year period, however, is limited. The visa is not extendable. So at the moment, the countries that are covered doesn't include any EU countries. So we'll just wait to see whether that will be expanded to include EU countries in future. And the final route to mention is the government authorized exchange route, which essentially covers interns and will be extended from next year to allow you to sponsor EU national interns under this route. So that's just a flavour of the other visa routes that you might have available outside the sponsored visa options. So coming on now to the crucial bit, how do you prepare given all the changes we've outlined coming ahead? Now, the first area we want to touch on is really in relation to right to work. So there will be big changes in relation to right to work. We've said that EU free movement rules will be ending, and that will mean that the current guidance and requirements around right to work will change because EU citizens will become subject to immigration control in the same way as your non-EU nationals. So as an employer, you need to obviously prevent illegal working and need to continue to make the relevant checks at the point of recruitment and also on an ongoing basis where you have people with time-limited visas. So the documents you will need to check will depend on what the individual status is and their nationality. So for your existing EU employees, now we've mentioned they're covered under the withdrawal agreement, so they have to apply for settled status under the new scheme. So you would be checking for those employees that they've made an application. Where you have new hires who are moving to the UK who aren't covered by the withdrawal agreement, so they haven't arrived before the end of this year, they will be subject to the new immigration regime. So this process is outlined for skilled workers. Now, you may have people who you recruit next year, but who have actually been in the UK prior to the transition period ending. So they will fall into the group of people who can qualify for the EU settlement scheme. So when you're recruiting from next year and you have an EU national, there will be sort of 2 routes by which they might be able to show you that they have a right to work. You may need to check documents online. So for those of you who have seen confirmation of EU settled status, you'll be aware that there's no document, there's no visa card issued, and individuals will give you a code that you will need to check online to confirm their status. So it's worth bearing in mind the new requirements around sort of when you can check online and when you need to check physical documents instead. So it will be important to make sure that you're aware of the new guidance once that is issued, probably later on this year.
Major, can I ask you two quick questions which relate to this? So one of the questions is, if an employee's already obtained their settled status or pre-settled status, and you've seen the online confirmation on the portal, what record do you need to keep of having checked that? Do you just take a screenshot of the settled status, or how do you keep your right to work check records up to date?
Yeah, so that's a really good question. So it's really important that employers are checking on the right side of the portal. So you need to be checking on the employer portal and be entering the details from the individual with the share code, provided you've checked on that portal. So you need to check yourself live and not accept the scanned copy or a screenshot from the individual. But once you've checked online on the correct portal, you then take either a PDF printout or a paper printout if that's your filing system, or keep a screenshot to confirm that you've done the check. And the information you'll receive, it will clearly show that it's a check that's been done for right to work purposes.
Thanks, Moji. And there's just one other follow-on question here, which is really, how do you manage this tricky period at the beginning of next year? So for anyone to qualify for the settlement scheme, they have to be in the UK by the end of this year, but they don't have to apply until the 30th of June next year. So you've got this 6 months at the beginning of next year where you won't necessarily know if you're recruiting an EU national, whether they've been in the UK prior to the 1st of January and they qualify for the settlement scheme, they just haven't made the application yet, or whether they're going to need a work visa. Yeah,
that's a really good question. And I think it's been one that's, it keeps coming up. And the government, I mean, when we've raised it with the Home Office, they've suggested that actually for employers won't need to check they won't be required to only check EU settlement scheme approvals until the deadline has passed. So there will be a period of time when you are, as an employer, accepting evidence of either somebody's EU settlement scheme application or approval, or their EU passport or ID card. But clearly, where people have arrived after the transition period has ended, they won't be covered by the withdrawal agreement or the settlement scheme. So you'll need to check that and confirm the date they actually arrived, so that you make sure that you're actually following the correct procedure. So, and hopefully we haven't had definitive guidance around that as yet, but I expect there will be some sort of a policy document or guidance from the Home Office that will set out clearly what employers need to be assessing and checking. But I think for the moment, it's important to be aware that there will be that tricky period, and trying to have an understanding of when somebody arrived in the UK would probably be helpful to ensure that you're in the right zone of the documents check.
Yeah, and remember that the onus is on the individual to demonstrate to you that they've got the right to work. So if someone's saying that they qualify for the settlement scheme, then I would be asking them to apply and demonstrate that prior to recruitment, because the applications at the moment are being processed pretty quickly. So that shouldn't be an issue. It stops you having to go down the route of having to think about a sponsored visa for them. Okay, well, just to finish up then, what else can you be thinking about in order to prepare for next year? Well, first and foremost, I've said this a few times already, but I sound a bit like a cracked record. If you don't have a sponsor license already, then make sure you apply for your sponsor license. That's your #1 key priority for next year, because you're going to need that to employ anyone from outside the UK, whether they're an EU national or a non-EU national. And the sooner you do that, the better, because license applications are taking around about 4 weeks to process at the moment. But we think there's going to be a big bottleneck at the end of the year when lots more employers will apply for licenses, and that will slow things down quite a lot. Secondly, just to repeat what I've said earlier, worth checking that you're registered under intra-company transfer as well as Tier 2 General, if they're both applicable to you. And then if you're not, making your application again as soon as possible. And if you do have a license, then it's worth auditing your systems just to make sure that all of your documents and compliance obligations have been met, all of your ducks are in a row, so there's nothing that's going to jeopardize your recruitment from next year. And we've been doing lots of audits or reviews with clients just to check that the documents are all there. Often there are one or two things missing, and it's just about getting those as up to speed as you can, ready for next year. The third point there is around budgeting and planning. So we've talked a lot about the additional costs that you're going to have to face for EU nationals. So some of our clients are thinking about, well, how many EU nationals on average do you employ, and where within the organisation are they sitting, and what will your recruitment needs be going forward? And if you had to recruit the same level of EU nationals, then what would the visa costs look like if you're having to get sponsored visas for them? So it's worth doing a bit of an analysis on the financials there. And then finally, training and upskilling. As Modi said, there are going to be new right to work requirements, new visa requirements and processes. So just thinking about what internal processes you need to support that, who within the organization needs to know about those changes, and how are you going to educate them? So some training and upskilling. You know, a lot of the information is yet to come, particularly on right to work, but it's about, again, planning and making space for there to be some training in the latter part of this year or early next year, so everyone is up to speed. Okay, that's quite a bit to put on your to-do list, but I think that covers everything that we were going to talk about. We've just got a couple of minutes now to pick up some of the questions that we haven't yet touched on. So one of the questions was, I've talked a lot about applying for a sponsor license, and the question is, how do you go about doing that? It's actually a relatively straightforward process. It involves an online application, but there are some key supporting documents that you need to get your hands on, and that can take a little bit of time. And as I said, the applications are taking around about 4 weeks to process. That might end up being a bit longer later this year. The other aspect to it is making sure that you've got the record keeping and compliance processes in place to support your license application. And that process is very much the same whether you're applying for a license for the first time or applying to add a category to your license.
So another question that's come up that I think is is relevant here is around when you do, if you do already have a license, what steps you need to take. And I think Adam mentioned there around making sure you've audited your records. The other thing to be aware of is thinking about, well, how many additional certificates do you think you might need looking ahead to your recruitment next year, and then filing a request for that to be allocated to your license. Now, there's no restriction on requesting certificates, but you do need to be able to justify the reason. So you need to be able to confirm why you think you have that recruitment need.
Yeah. There's another really good question here around salary thresholds. So we talked a lot about salary thresholds earlier, and the question is, if you've got someone in a commission-based role, how does that work? Do you count just base salary, or do you count base salary plus commission? For the salary threshold, you can only look at guaranteed commission. So that would only be base salary, guaranteed allowances, any guaranteed bonuses, but any discretionary bonus or discretionary commission, which is not guaranteed, can't be taken into account. So you're only looking at the guaranteed element. Another question here, if someone already has settled status in the UK and has been in the UK for a while, do they need to apply for a visa? There are a couple of parts to this. So if somebody already has permanent residence under the existing EU rules, they would still need to apply for settled status under the new EU settlement scheme. But if anyone's got settled status or pre-settled status by the end of this year, or indeed by the 30th of June next year, then they won't need a sponsored visa. They won't need a skilled worker visa or an intercompany transfer visa or anything like that. You just rely on the settled status or pre-settled status.
And just a related question to that, if somebody arrives just before the end of the transition period, will they still be covered by the settlement scheme, and what documents would they need to, would they have enough information to apply? Well, they would, as long as they arrive and have evidence of their arrival, so say their travel ticket, they would be able to show that they fall into on the right side of the settlement scheme, and would still have till the end of June 2021 to make their application. So I think the key thing would be making sure if somebody's coming towards the end of the transition period, to make sure they've kept evidence of the dates they arrived, even if they, they then need to gather more documents in order to apply, although technically they could rely on the travel information to show they're here.
Great. Well, we've just ticked over 4 o'clock, so I think we probably ought to end it there. But just to say, Moji and my details are there on the slide at the end. So if you've got any questions that we haven't covered or anything else that occurs to you, please feel free to get in touch. We'll be very happy to answer your questions. There was a question around, will we provide a copy of the slides? And we absolutely can do that. So we can email all the attendees a copy of the slides, so you've got the slide deck with you. Well, it just leaves me to say thank you very much for joining us this afternoon. We'll look at holding some further webinars later in the year or early next year in relation to the new regime once a bit more detail has come out. So we will keep you up to speed. But in the meantime, thanks again, and hopefully see you soon.
Thank you.